Welcome everybody. This is Business Law at Columbia College. My name is Cassandra Jenneke and I'll be your instructor for this course. We are on class 10. Today we're going to be talking about discharge of contracts. So by way of review, thus far what we have talked about is we've talked about how you create a valid and enforceable contract, and that is by utilizing the 6 elements, right? An offer, entered into by 2 or more competent parties with the mutual assent of those parties, supported by consideration for a lawful purpose, and in the form required by law. In our last class, we talked about what happens when a contract involves or implicates the rights of a third party. And today what we're going to be talking about is what happens after you have a valid and enforceable contract, and that's namely discharge or performance of contracts. Now, here's what I'll say. The vast majority of contracts are discharged by performance. The parties do as they are supposed to under the agreement. Someone buys a car, pays the money to purchase a car. Those types of performances happen every day. But there are certain circumstances that we'll talk about today where perhaps performance isn't adequate, where perhaps performance doesn't happen for a variety of reasons. And so by going through that information today, what we're going to identify is what happens or what constitutes a breach of a contract. So the first thing for us to talk about is a special issue related to performance. And that is the concept of conditions which are related to performance. So there may be a contract that you enter into that the performance that's called for under the contract is not triggered until something happens, right? Or it may be that a contract will be canceled as a result of something happening in the future. So this is the issue that we are presented with, an if-then scenario. So these 2 types of conditions are classified as conditions precedent and conditions subsequent. So one of the things that we talked about when we talked about offers and acceptances is that the terms of your contract have to be such that a person looking at your contract know that a contract A existed and B what the terms are. And your contract can't be so vague as to not imply or describe what those conditions of performance are. So a condition precedent is one that has to occur before the party is obligated to perform on the contract. A condition subsequent is the reverse of that. So it's an event whose occurrence or a lack of occurrence can cancel a contract. Those conditions are strictly construed, and if they are ambiguous, they will be construed against forfeiture of the contract. So if you're going to have a cancellation provision in your contract, you need to make sure that it's not ambiguous, because if it is ambiguous, a court will look at it and say, well, I don't know what you meant by that, so you're going to be bound by the contract and you have to perform as required. Now, concurrent conditions are exactly what they sound like, right? That's the mutual duty of performance to take place at the same time. This is how most bilateral contracts occur, right? Someone is constructing a building, payments are being made during the construction of the building, performance is occurring simultaneously. As I mentioned, the normal discharge of contracts is simply that they are performed, and they're performed by the time specified in the contract. But some of the questions we'll answer today are really going to be about what is insufficient performance, so inadequate performance, and what happens when someone fails to perform, okay? So when we talk about performance, some of the verbiage gets a little weird. So tender, not like tender-hearted feelings, but tender, which is the giving of something, okay? Tender is what happens when you, as a party to the contract, offer to perform underneath that contract, okay? So if I offer to make a payment and the other party refuses to take my payment, then the reality is that their refusing to take my tender discharges my duty to continue performing. And then it's a way for me to say the other party breached, and now I get to sue them for failing to perform. Valid tender of payment is where there is an unconditional offer of the exact amount due on the date when it's due. You don't get to offer payment late. You don't get to offer payment early. You don't get to offer less than the payment that's due. You have to offer what's due when it's due. Now, a tender of payment is not simply an expression of a willingness to pay. It has to be an actual offer to perform by making the payment. So I can offer to perform, I can attempt to tender, but if someone refuses that payment, then they are the ones that are in breach. So if any of you have, let's say, multiple credit cards with one company, right? You have multiple Chase cards. You have a Freedom card and you have a Disney card. That might be my life. And so when you owe more than one debt to a particular creditor, the creditor is bound to apply the money as specified by the debtor. So if you don't specify how you want payment made, then the creditor can apply it in any way that they want to, and typically to their benefit, right? To the least amount of interest owed, or the principal that has the least amount of interest to accrue off of it. So this happens less and less now for our typical consumer, because if you utilize any online banking or online payment options, you'll see that you often have the option and are in fact required to make payments attributable to a particular debt that you owe. Same thing for student loans, same thing for private loans. Now, so best tender, right, is hard cash, right, or a cashier's check. There's no question, absent counterfeiting, as to their viability and ability to be cashed, right? If you pay by check, a check constitutes a conditional tender of payment, okay, that we will consider made at the time that it's mailed or before the final due date. You send off a check, for some reason the check bounces. If it bounces, then you, as the check paying party, are going to be in breach of your contract because you failed to perform as required under the contract by sending in a bounce check. Don't send in bounce checks, for clarity. Don't do that. It's a crime if you know that there's going to be insufficient funds. So don't do that. Okay, so we talked a little bit about with tender of performance, like how performance can happen, right? You make the offer to perform, you offer up money, you offer to do the thing that you are required to do under the contract. But what time do you have to do that within, right? So most contracts, because again, Cassandra's rule number 1, contracts can be written. You should, if time is important in your contractual relationship and into having the performance done that's required under the contract, you're going to specify what time, because otherwise, where you fail to specify a time period for performance, then the court is going to look at that and say, well, what's reasonable? And what's reasonable is going to be implied by the relationship that you have with the other party, any prior contractual agreements that you've entered into, what the performance is that's called for. So if time is important, then specify a time. If you do specify a time, you can specify time in a variety of different ways. So you can give a particular time period. Okay, you can give a date due by. You can also say time is essential, which I would recommend doing if time is in fact essential, because then failure to perform within that specified time will absolutely be a breach. Okay, you can waive. We haven't yet talked about waiver, but we'll talk about waiver a little bit today. First here, and then again when we talk about discharge by the parties. You can waive error or breach of a contract because of a time limitation issue. So if the specified time has expired under the contract, but the party who could complain about the lack of timeliness, right, still requests performance, then they have waived the ability to sue the non-time performing party for that breach. If you want to sue them for that breach, then you can't have them perform and accept their tender of performance. Because if you do, then you have waived your ability to sue them for the time breach. So we've talked about this concept of adequacy when we talked about consideration, right? Typically, courts don't care, right, when we think about consideration, about whether or not consideration was adequate. They just don't. But when we're talking about performance, courts utilize a lot more leeway in interpreting what is adequate performance, because by the time you get to performance, somebody's out something, right? If somebody has performed something under the contract, then it gets a little bit harder for courts to say, oh, nobody gets anything, right? It's that equity monster rearing its ugly head back in our courts of law. So there's this concept under adequacy of performance called substantial performance, and you'll see here that I've abbreviated it SP just for ease of typing. But substantial performance is an equitable rule that if there is a good faith, that's what that GF stands for, performance that doesn't precisely meet the terms of the contract, but mostly does, right, because it's that good faith performance, then the agreement will still be considered completed and performed if the essential purpose of the contract is accomplished. So a party who in good faith provides substantial performance on a contract will be entitled, in exchange for that substantial performance, what they earned under that performance. So let's talk a little bit about that. So you'll see here that there's this cost of completion versus diminution in value. So cost of completion is the cost of repairing or correcting the performance that isn't exactly right as an offset to the payment that was owed under the contract. Versus that with diminution in value, sorry guys, my alarm's going off. Where the cost of completion would be unreasonably disproportionate to the importance of the defect. This is specific in cases where the damages caused by the failure to perform as required under the contract results in a decrease in value as a result of the defect. So let me give you an example. And it's an old one that's from a case, early 1900s. So a man, a head of a family, contracts with a builder to build a brand new home. And he, in the contract, requests that and the contractor agrees to put a particular brand of piping in their home. And they do that because the guy who's buying the house, having it built, is the head of that pipe company. So he wants his pipes laid into his house in the way that he wants. Okay. So contractor goes through, they're getting ready to put in the pipes, and for some reason, he doesn't put the pipes in. He puts in the same quality of pipes, but a different brand into the home. And so at the end of the house completion, Joe Schmo, the pipe owner, is like, hey, did you put the pipes in the way that I wanted with my pipes? And the contractor's like, hey, no, I didn't. Sorry about that. Same grade of pipe, same quality of pipe, but we didn't put your pipes in. There was a miscommunication. They weren't available, what have you. Well, Joe Schmo, the pipe owner, blows his top, right? Because he specifically requested that those pipes be put into his house. So he sues the contractor for breach of contract. Okay. Here's the deal, though. Substantial performance. The contractor, good faith performance by putting in the same quality of pipe, the same grade of pipe in the house, doesn't precisely meet the terms of the contract, but man, did he try. What did the guy get? Joe Schmo, the pipe layer. a whole house, which is what he contracted for, right? So the essential purpose of the home has been accomplished. Now I ask you, different brand of pipes, same quality, nothing different about that. Do you think it would be appropriate for the court to order the house demolished to start all over again? Because, I mean, damn, pipes are at the very beginning, right? So you got to take everything out. Or would it be more appropriate to assign a certain price or assessment, sorry, as an offset to the payment that the contractor is owed under the contract, right? So here, really, the problem is that, can you really cost it? The cost of repair is going to be enormous, right? Because you got to tear down the whole house. So cost of completion, it's not really appropriate. But if you look at the diminution in value, right, the decrease in value to the home as a result of the different pipes being used, right, different brand of pipes being used, can you, and typically you can assign a certain amount to the decrease in value to the home. So here, the cost of completion is totally unreasonable and disproportionate to the importance of the defect. Like, if the guy had asked for brass pipes and he had gotten PVC pipes, we would be talking about two very different things, right? And the defect, you would need to correct that. You would need to repair that. But under this scenario, because they're the same grade, same material, just different brands, here what we would do is, yes, there was a breach. Sure, absolutely there was a breach. But you're not going to get cost of correction or completion. You're going to get diminution in value because it would be unreasonable for us to expect us to tear down that whole house to put the correct brand of pipes in. Okay, so some factors to be considered. And in that case, that's what they ordered. They ordered diminution in value rather than cost of completion or correction, because there was no way that the court was going to order this contractor to tear down the whole house just to replace the pipes with a different brand of pipe. Not going to happen. Some factors that we consider in whether or not substantial performance warrants a cost of completion award or a diminution in value award for the breach, and whether or not substantial performance is enough to not just constitute a breach, right, is based on a lot of different factors, but particularly the willfulness of the contractor in deviating from the contract terms will be included in the court's consideration. So if the contractor did it to be a jerk, had no good reason to do it, there may be a very strong possibility that he's going to have to tear down that house and rebuild it. But if he did it because there were no pipes available, if he did it because the city requires, a certain type of pipe or a certain width of pipe, then that would probably be a reason that would warrant application of the substantial performance rule, and then would require diminution in value to be offered rather than cost of completion. Now, take our prior house example, right? And think to yourself, well, what if Joe Schmo, the pipe owner, made it so his pipes weren't available, right? It's not a really large pipe company. He doesn't have that much inventory, and he takes on a whole bunch of jobs where all of his pipes and all of his stuff is going to there, and there's just no pipes available for his own house. He doesn't get to complain that performance is defective because he creates a situation where the breach occurs. So if it's his fault that the pipes are not available, you don't get to complain about the breach. So again, thinking about how specific our terms have to be in a contract, right? That offer and acceptance piece. You can require that a contract be performed to the satisfaction of the contracting parties. What in the world does to the satisfaction of a party mean? Oh, well, to me it seems a little vague, but This is a valid requirement in many, many contracts. So the courts will enforce to the satisfaction of the parties by the plain meaning of the language of the parties that's used in the contract, and the work must be satisfying to the contracting party. If it's not, if a party is in good faith, genuinely dissatisfied with performance, then the other party has to perform until they get it right. So this good faith, personal satisfaction type clause, you're generally going to see them where the subject matter or the purpose of the contract is personal, right? So it's going to be contracting for art. It'll be for, you know, if any of you get, I mean, I'm short, so I have to get all my pants hemmed. So tailoring, okay. Design work. If you have an interior designer come into your home and do stuff. Those are the types of things that could implicate a good faith personal satisfaction clause. Now, typically, right, contracts are not discharged by the actions of either party alone. Most contracts are unilateral, okay? Some contracts can give unilateral power to terminate or to cancel for one party. But those cancellation provisions have to be in the contract. So insurance policies, for example. Insurance policies will have in there that, hey, if you don't pay, we're going to terminate your stuff, and that's just it. That's a unilateral power to terminate or cancel. Okay? Some things for you to know about, in California in particular, there are these things called cooling off laws, which are awesome. They do not, for clarity, apply to the purchase of a vehicle, but they do apply to you taking out any credit transactions related to your home. So in California, you have 3 business days to cancel unilaterally with no negative implication on you, your credit, no, you're not going to owe anything for canceling early. You get the option to cancel within 3 business days of entering into the transaction. And that is because we recognize that Joe Schmo the lender, or Joe Schmo the debtor, right, is 100% at an unequal bargaining power with creditors and bankers, right? Like, they are professionals. They are people who are savvy in the ways of credit transactions, whereas, you know, your regular guy on the street may not be. So they are less sophisticated, and that's why we have these consumer protection rescission laws or cooling. Now, as I mentioned, most contracts are just performed, right? People just perform them. But sometimes you get into performance, or performance hasn't started yet, and you don't want to perform under the contract anymore. So you can, by agreement, discharge performance of a contract, so eliminate performance of a contract in 8 different ways, and they're all listed here on your screen. Your book does a really good job going through each of them, so I won't go into them in any great detail. Okay, you need to familiarize yourself with what this looks like. But obviously, if there's a cancellation or just discharge term in your contract, you can do that. You can both agree to cancel the contract, and then it's canceled, and that's it. Okay, it's another agreement. It's another contract. It's a contract to cancel a contract. You can rescind a contract, which is basically annulling it and returning both parties to their original position. So anything that's been exchanged, it goes back. You can substitute the same parties with a new contract that will discharge the old contract. So let's say you've agreed to do something that doesn't work anymore. Let's do something new. Same parties, different deal. And in this new contract, we're going to say, hey, this old contract, it's gone. We agree. It's gone. It's been discharged. Don't need to worry about it anymore. You can novate out a party, so you can put in a new party, same old contract, but a new party. If you have a disagreement about performance, you can then agree to a new type of performance, which becomes an accord, and then performance of the accord becomes satisfaction, and it discharges the old contract, right? It means that you no longer have to perform that old contract because we agreed and came to an accord, like a pirate, that this was how we were going to discharge this contract, okay? You can also release people from a contract, okay? So you can release any further claims or causes of action against the other party. That can discharge your performance. And then lastly, waiver, right? And we talked a little bit about waiver when we talked about waiving that time is of the essence clause. But you can waive a breach. And let's say you waive it because, listen, somebody made a mistake, a delivery came in a day late, you still want the stuff. You can forgive that and move forward, right? By doing that, you are discharging and disavowing your ability to sue that person for that breach because you are agreeing by waiving that performance has been discharged. Keep that in mind. So life isn't easy, right? And we all know this. 2020. Ugh, right? So sometimes performance can be discharged by external causes, okay? And we recognize that there are just certain things in life that A, we can't control, and B, we can't prevent, and that C, we can't anticipate when we contract, okay? But courts don't like to discharge performance because of external causes, okay? They want you to perform. And so if you can just say, oh, well, it's become impossible now, almost everybody would not perform and they would just go on their merry way with no repercussion, right? And then that negatively impacts our ability to contract. So people aren't going to contract because there's no protection in it. So I say that to preface us going through the external causes of discharge to say that these are hard to prove and they're hard to argue, okay? So discharge by impossibility. If you want to go to a court and say, hey, listen, judge, I can't perform anymore and I need you to discharge my duty to perform under that contract because performance has become impossible, here's what you have to prove. You have to prove, one, that there was an unexpected occurrence of an act, okay, something happened, whose risk was not allocated for by the agreement itself or in the customs associated with that type of agreement, and that occurrence has now made performance, quote unquote, impossible, okay? It has to be so extreme to prevent you from performing, okay? Let's say, for example, you had a contract with Union Hill to get married on their property, and it happened to be in a month, except the entirety of Union Hill burned down in a fire, right? The place where you're supposed to get married at Union Hill burned down in a fire. This happened a couple years ago. It has now become impossible for them to perform because you can't get married in the place where it burnt down, okay? This requires an objective impossibility. So there must be a real impossibility that is more than a mere inconvenience or an unexpected difficulty, because those are things that you are supposed to anticipate as a contracting party. This is rarely going to work as a defense because failure to perform a contract that you entered in voluntarily, courts don't care if you can't pay, right? Financial duress, not an excuse. Financial impossibility rarely works, okay, in a very similar way. Now, some ways for you to think about impossibility as well. Let's say I contracted to purchase the last Monet painting that is owned privately outside of a museum. But the painting is destroyed by a fire before I get the painting. It's gone. It's impossible for me to turn it over. So what will happen is that the parties will go back to where they were. Unfortunately, the person who has a burned up Monet is boned, but you get your money back, right? Because performance has now become impossible. Okay. Specificity in the subject matter is required in those types of contract. So for example, my description of the Monet, probably not adequate. You need to describe how big it is, when it was done, a serial number if one exists, that kind of stuff. You got to be real specific. Okay. If there has been a change in the law such that performance becomes impossible, impractical, or illegal, court will discharge performance because of that external cause. Okay. If a person, a party to the contract, dies or becomes disabled, then the contract will be discharged by their death or disability if it is a personal services contract for a peculiar or particular skill. So it doesn't apply when an act can be performed by others. Okay, so if you're in contract with a company and you're working with a particular employee who you really like, he's super smart, but that person dies, that doesn't mean that your contract is discharged, right? That your requirement to move forward on that contract is discharged. What that means is that the other people at the firm, they got to do the work. They may not be as good, but too bad, so sad, okay? If your tailor dies, though, then you don't have to perform because that person's death has discharged their duty to perform, right? Because they did, and they can't perform. If an act of another party prevents you or makes performance impossible, that's a breach by that other party. Okay, so then your performance is discharged because that person is breached. So I just spent some time telling you about how impossibility is not a really great defense, right? It's real hard to prove. It's got to be objective. It's hard. So courts have recognized that common law theory to excuse performance doesn't recognize the very real world situations that can occur. So the law, specifically the UCC and many states, have developed and incorporated the concepts of commercial impracticability and frustration of purpose to address what can happen when stuff goes wrong and makes it really hard to perform. So commercial impracticability was definitely developed in response to the almost impossible rule of impossibility, right? So this is available as an excuse to not perform when performance has been made impractical by a subsequent occurrence that's an event that you couldn't anticipate and was not a basic assumption made in the contract, okay? So if you enter into a contract, something happens that now makes the purpose of the contract illegal. You entered into a contract with the basic assumption that what you were doing would be legal. You can't perform an illegal contract, right? So now it has been made impracticable and impractical to perform by virtue of that subsequent occurrence. Okay? This will typically not relieve sophisticated business entities in the instances of economic downturns or market shifts, because those sophisticated parties are supposed to be able to anticipate those turndowns and shifts and be able to recalculate and perform even though things are going wrong. Now, frustration of purpose, pretty similar, okay? A change in circumstances that causes the purpose of the contract to have no value, okay? So impractical performance versus performance has no value now, right? So if you have a purpose or an intent section of your contract, which you will, because it makes things real easy for the court, and all parties are aware of that purpose, where the change that has created this frustration of that purpose was unforeseeable, you're going to discharge performance. A court will look at it and say, hey, listen, you guys entered into this agreement thinking one thing was going to happen, and now another thing's happened, and the whole purpose of your contract is gone. Purpose has been frustrated. We're going to discharge performance, and we're not going to find anybody in breach because, listen, this external thing happened, and now there's really no purpose in you performing. Force majeure clauses are really fascinating. So I did Model United Nations in college, and we hosted our own conference for high schoolers. And so I'm meeting with hotel executives so that we can enter into contracts to use their facilities for this this conference that we were hosting. And I get to this clause that says force majeure, and it talks about acts of God and how the hotel won't be on the hook if acts of God happen and we still have to perform. So we still have to pay them even though we don't get to use the hotel. And I'm like 19. I have no idea what I'm doing. And so I look at him and I'm like, what does this mean? And he's like, oh, it's in every contract. He was totally right. They're in every contract. So basically, what modern contracting parties have done is contract around the doctrine of impossibility, right? By specifying that unforeseen events or uncontrollable events will not excuse performance. Fun fact. Temporary impossibility will suspend your obligation to perform, but not eliminate it. Okay, so it's not complete discharge, it's just suspension. Weather conditions are an assumed risk, and so you just have to assume that weather may be good, weather may be bad, but people still have to perform. So many contracts have a weather clause where the parties will buy insurance to cover the risk in a contract related to weather. It's definitely something that can happen. And then lastly, one of my favorites, discharge by operation of law. So a bankruptcy oftentimes eliminates ordinary contract claims because once somebody goes bankrupt, they're not going to have the money to make a payment. Statute of limitations can bar contract claims. So let's say, for example, somebody breaches a contract, and in California, it's 2 years for a contract breach. If somebody breaches a contract in 2017 and the party goes to sue them in 2020, their performance has been discharged because their statute of limitations has expired. And so not only can you not sue them for the breach, but now they don't have to perform because you didn't sue them in time. And then lastly, you can create a private statute of limitations by the agreement of the parties. So if you say, hey, listen, if I do a breach and you don't sue me within 5 months, you waive the breach. Okay. So that's a little bit about performance, a little bit about breach. Next time when we meet, we're going to talk about what happens when a court finds that there was a breach and what you get in return for it. So get excited for that. I'll see you guys next time.